Asking your questions, getting your answers. This is your show. Here's your host, Adam Schrager.
Good morning and welcome to your show for Sunday, June 8th. We hope you're having a good day so far. Now, we posed your questions to former presidential candidate Mitt Romney, and we'll air that segment a little bit later on in the program. But first, a rare opportunity to sit down with the leader of Colorado's highest court. We asked your questions to State Supreme Court Chief Justice Mary Mullarkey earlier on this week. Chief Justice Mary Mullarkey, thank you so much for being on your show.
Thank you.
Our first question, Teresa, who's just finishing her first year at University of Denver Law School, wants to know, do you ever wish you were on the other side of the bench, advocating an issue instead of deciding it?
Oh, certainly. Yeah, and I think that happened to me more when I first became a justice than it does now. But I had done a lot of appeals. That was my specialty. And occasionally we would have cases where it was very obvious that the attorney wasn't enjoying being there arguing a case. And so that the temptation then was to say, well, gee, I'd like to be on the other side. I would have argued it this way.
Following up, I'm going to give her a second question because it's interesting. She said, as a law student, that someone told her judicial activism, she writes, is really just doing your job. Do you agree with that? We hear that phrase all the time.
I think judicial activism means a lot of different things to different people. It's often used as shorthand for reaching a result, and usually that the speaker doesn't like, and therefore to say that this is judicial activism. But it means all kinds of different things to different people, and the definition she was giving is a very friendly sort of definition of what just judicial activism would mean to somebody else.
How do you define it?
Well, I don't use the term because I don't really think it's very helpful. I think we ought to talk more in terms of whether the analysis was done well in a case and those kinds of things. Does it seem like the opinion that came out was true to the law and the facts?
We received a number of emails, and it shouldn't surprise you, of people who, as you said, sometimes the speaker, who have troubles one way or another with the system. And without being case specific, Johnny Martinez, Todd Margolis writing in, how does the justice system reconcile, with his words, selective enforcement of our laws?
To have to do with the criminal justice system. And in that area, the prosecution does have a lot of discretion over which kinds of cases to pursue. And I'm not sure what he means by selective prosecution, but certainly there are many cases that the police present to the district attorney, many more than the district attorney actually chooses to prosecute. I think it's the district attorney's responsibility to go through those cases, figure out which cases are strong cases and that he or she wants to pursue in a court. So it is selective in that sense that there is someone, the elected district attorney, who has to exercise discretion in which cases to pursue.
In some cases, too, let me fast forward to the end, where should justices have some flexibility as far as decision-making in the courtroom, sentencing guidelines? How important is that flexibility?
Well, yes. On our court, for example, we have flexibility in the cases we choose. We have a discretionary review of a lot of appeals. We must take certain appeals, but the great majority of the cases that come in front of us, we can decide whether or not to review them. And we do that by looking at the nature of the case, the type of issue that's presented, whether it has a big impact on the population or whether it's just of importance to the people involved, those kinds of considerations.
It should come as no surprise to you that when we advertised that we had you on the program, we got an email from former Senate President Andrews, who had forwarded a ballot initiative dealing with judicial term limits. And his question for you is, how do you assess the level of public discontent with the judiciary? Is there a discontent?
Well, how do we measure the level of it?
How do you assess it?
One way we're trying to assess public reaction to the judiciary is by doing surveys, and this is done on the trial court level. It's very hands-on. Judges and court employees have been surveying people who appear in front of the courts, just as they coming to the courts or leaving the courts, and interviewing them about their experiences in the court and what kind of satisfaction levels they had with the courts. So that's a very hands-on, retail sort of way of getting at the satisfaction of court users.
What are you hearing?
Well, there have been about 3 or 4 districts that have done it so far. Most of it is pretty positive, but some of it brings up problems, and about use of court facilities, for example, that maybe the court takes too long, there's too much delay, that kind of thing.
I wanted to ask you a question. It hasn't been an issue here in Colorado, certainly in a number of years, but at the federal level there was concern about the safety of judges. And a gentleman by the name of Simon Barker wrote in asking, are you ever afraid of your safety in your role as Chief Justice?
Well, we have security at the building here, and provided by the security division of the State Patrol. And I think that they're very well trained and know how to handle people who come to the court building. We also have had a fair amount of training on how to deal with threats and that sort of thing. I don't personally feel unsafe.
Does that come with the territory, I would imagine, of when you want to be a judge?
Well, I don't want to give it that much credence, because I think most people are very respectful. One of the things that continually amazes me is how well we are devoted to the rule of law, that people will accept the decision of a court. And you see this happen all the time in trial courts, where someone loses a case and accepts the decision. It may be a criminal case and the person is sentenced to a lengthy term in prison. And for the most part, people accept these decisions and move on from there. So it's really quite a tribute to our system.
You talked about the rule of law, and I'm going to ask you a question that's a little out of my expertise here, so I apologize. But it comes from Lonnie Weems, who says he's aware the Colorado state statutes are based originally on statutes laws suggested from Missouri, which go back in time to even English law. His question is, if he's assuming that the basic foundations of law and justice have been under discussion for quite a while, is that a conversation that's still progressing?
Sure, of course, and it takes place in not just in the courtrooms, but also in the legislature, because the legislature has the power to make laws, and they change the common law. It's true, when Colorado became a state, we adopted the English common law to the extent that it wasn't statutory law. But ever since then, for the last, how many, over 150 years, the legislature has been making laws incrementally to re-examine a lot of these premises that he's talking about, the really ancient common law.
One of the non-legal components to your job, and this question comes from Rob Whitwer, who's a state representative who's leaving now, asking about your thoughts about the role of the court in the upcoming reapportionment, the redrawing of state legislative seats, and just how important it is. Do you see your role as being nonpartisan there, or is there a partisan side that plays a role in that? Well,
I think he's probably talking about the way state reapportionment is done, and
right.
And by Constitution, there is a role for the Chief Justice to play in selecting the members of the Reapportionment Commission, and so that it's all set forth in the Constitution exactly how that goes. The Chief Justice makes the final set of appointments, and then the court ultimately can approve or disapprove the plan. So the court is involved in that reapportionment from several different angles. So it's very important to try to pick people for the reapportionment commission who are good thinkers and who will be fair about resolving the question of dividing up the districts. It's always controversial.